This is Barry Zalma on insurance. I am an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness, an author, and producer of these videos. Today I'd like to continue in the discussion of various exclusions in insurance policies, starting with the exclusion for a much aligned exclusion, that for inherent vice. Inherent vice relates to internal decomposition or some quality which brings about the object's own injury or destruction, not an extraneous cause. The subjective test for fortuity raises questions regarding whether the inherent vice exclusion is effective. For example, the exclusion in Lloyd's stamp collections form provides, quote, "This insurance does not insure against fading, creasing, tearing, wear, tear, inherent defect." Similar language appears in policies issued in the U.S. by the Insurance Services Office, where Form BP 00021299 provides these exclusions. 1. Wear and tear. 2. Rust, corrosion, fungus, decay, deterioration, hidden or latent defect, or any quality in property that causes it to damage or destroy itself. In Minnesota, in a case in 1927 called Chute versus North River, one of the earliest non-marine decisions discussing inherent vice, the court recognized the effectiveness of the exclusion. The policy insured against the risk of loss to a fire opal. Because opals are fragile gemstones, the opal cracked. In holding that the policy did not afford coverage, the court stated, "Plaintiff purchased and defendant furnished indemnity against loss or damage from fortuitous and extraneous circumstances rather than warranty of the quality and durability of chattels," personal property, because the policy must be considered as one against damage from fortuitous and extraneous risks. It is not permissible to resort to an ultra-literal interpretation which will convert it into a contract of warranty against loss resulting wholly from inherent susceptibility to dissolution. The term inherent vice has been defined to capture any existing defects, diseases, decay, or the inherent nature of the commodity which will cause it to deteriorate with a lapse of time. In American Home Assurance versus J.F. Shea, a 1978 decision of the District Court of the District of Columbia, the court, in connection with the collapse of support of an excavation system, found that an inherent vice exclusion in the policy did not bar recovery under the policy because the collapse resulted from an earth slippage, an outside force resulting from acts of nature, and because the insured property did not contain its own seeds of destruction. An Illinois court, following a Texas court decision, disallowed coverage for the replacement cost of a defective pipe under the policy exclusion for inherent defects, but allowed coverage for ensuing damage to the wall and floor that followed when the defective pipe burst. This is Board of Education versus International Insurance, a 1997 case from the Illinois Court of Appeal. An inherent vice, again, is defined by various courts as existing defects. The vice must be inherent in the property for which recovery is sought. In other words, the question is whether the insured property contains its own seeds of destruction, or whether it was threatened by an outside natural force. If threatened by an outside natural force, coverage would apply. If not, it would not. Adding to the inherent defect exclusion is the one dealing with latent defects. A latent defect is a defect that could not be discovered by any known or customary test. Analysis indicates that the latent defect and inherent vice exclusions are attempts to embody in the text of the policy the need for fortuity. An insurer can only reasonably be expected to insure against the happening of a contingent or unknown risk of loss. For example, in Compagnie des Bauxites versus Insurance Company of North America, a decision from 1983 in the Western District of Pennsylvania, the court stated, quote, "The law is quite clear that an insurer is not liable for losses resulting from inherent vice, defect, or infirmity in the subject matter insured, for this type of loss is not caused by chance or an extraneous event." Close quote. No insurer would sell fire insurance to a person whose house was on fire. A house with an inherent vice is as damaged. The damage is just not as easy to observe. A latent defect is a defect not manifest, but hidden or concealed, and not visible or apparent. A defect hidden from knowledge as well as from sight, specifically a defect which reasonably careful inspection would not reveal, one which could not have been discovered by inspection. Some courts have suggested that a narrow definition of latent defect and inherent vice does not mean an insurer has no choice but to cover unknown pre-existing defects. The insurer could, first, actually conduct the reasonable inspection upon which latency depends, including expert investigation and analysis where necessary. If this is thought too burdensome, the insurer could write into its policies an appropriate exclusion, phrased in clear and unmistakable language, such as the exclusion as suggested by the Court in Reserve versus Pisciota, a 1982 decision of the California Supreme Court. It stated, "Inherent vice means damage to the property, the risk of loss of which is insured, not apparent by reasonable inspection, by persons not expert in construction, design, engineering, and or architecture." Courts living away from the real world of insurance may think that by simply stating a rule, it can be carried out. They do not understand that when millions of homes are insured, to conduct the examination contemplated before a risk is accepted would make the cost of insurance prohibitive. If in the property insurance context, a latent defect is one which could not have been discovered by inspection. Rewriting insurance policies may seem simple to a court dealing with a single fact situation. The court, however, does not contemplate that since insurers are bureaucratic organizations, the time necessary to change a policy to comply with a court decision, especially when the policy has to be drafted to work in 50 separate jurisdictions, all of whom have insurance departments that must agree to the wording, takes decades to create. Also, if every word used in an insurance policy requires a separate and distinct definition, the policy becomes cumbersome, wording, and difficult to understand, allowing other courts to find an ambiguity that can be construed against the insurer. Probably the most common of all exclusions is the wear and tear exclusion. In fact, I recall reading a policy that I can recite from memory, and it stated, "We insure against all risks of physical loss except wear and tear," close quote. It's the shortest policy I have ever read in my 53 years in the insurance business. And when the client presented it to me, I immediately advised them to revise the policy wording. And they have done so with additional exclusions and conditions that now exist, and the old policy has long been discarded. The wear and tear exclusion, perhaps because it is so obvious, has seldom been the subject of appellate review. The phrase has been defined as following: construing the words wear and tear in their everyday common usage, we are convinced that the words mean simply and solely that ordinary and natural deterioration or abrasion which an object experiences by its expected contacts between its component parts and outside objects during the period of its natural life expectancy. This was stated in Cyclops Corporation versus the Holm, a 1973 decision of the Western District of Pennsylvania. The 11th Circuit Court of Appeal, reading a marine insurance policy's exclusion for wear and tear to not be ambiguous, it excludes coverage for losses and damages arising directly or indirectly from the cost of repairing or replacing a part, in that case an air conditioning hose, due to wear and tear. The exclusion excluded from coverage losses caused directly or indirectly by wear and tear, and it was undisputed that wear and tear to the air conditioning hose caused the fracture, and the fracture caused the boat to sink. The exclusion for wear and tear is not, however, as argued by the insured, limited to abnormal wear and tear, but rather encompasses all wear and tear. And in Lovell versus State Farm Mutual, a 2006 decision of the 10th Circuit applying Colorado law, held that when the language used in an insurance contract is plain and its meaning is clear, the agreement must be enforced as written. The policy at issue in the Lovell case unambiguously excluded losses caused directly or indirectly by wear and tear, marring, scratching, or deterioration. This video was adapted from my book, Zelma on Insurance Claims, Part 102, Second Edition, which is available both as a Kindle book and as a paperback from Amazon.com. If you found this video to be interesting or useful, please subscribe to my YouTube channel and my Rumble channel, and subscribe to my blog so that you can learn about future blog postings and videos. And we will discuss further other exclusions. And if you don't want to hear a video on it, consider buying the book, which discusses in detail many exclusions. Thank you again for your attention.